Hey folks, welcome back to the Law and Crime Network. This is the afternoon session. I'm Michael Bryant. Joining me here on set, we have Jason Friedman, former prosecutor, trial attorney, also Kirk Burkhalter, New York, what school? Law professor. What school?
New York Law School.
New York Law School. Very good. Guys are here. Also another guest to join us in just a moment. We got a lot of stuff to catch up on here today. I just noticed very humid in the city. I can tell because my hair, I think, is higher. I walk around with my own humidity changing device there. So the jury has spoken in the Hollywood Ripper case, basically guilty on all accounts. They're going to get back at it next Tuesday at 9:30 to begin the sentencing process there. Of course, these were first-degree murder cases, death penalty cases, but in California, there is currently a moratorium on the death penalty. So the real practical effect of anything this guy ultimately gets is kind of up for grabs. Joining us also, I mentioned Jason and Kirk. I also have Matthew Maddox with me. Matthew, thanks for sticking around. I know you endured Aaron Keller there, and that could be difficult. So I appreciate you sticking around. Let me ask you about this case and the verdict that we just heard and the impact of hearing about a case, the one against the victim in Illinois, that was not a decision for this jury, but was used for pattern, signature, that kind of evidence to get them, I think, to an easier guilty verdict. What are your thoughts on that?
Look, for a defense attorney, it
blows. Yes, I know. I think it's really very bad for defense attorneys. But I'm sorry to interrupt.
That's a technical term. It's a legal term, right? It blows. Yes. It is really, really very, very disturbing that bootstrapping and that piling on that happens. Not only, I mean, it wasn't even in California, but that piling on and the cumulative effect of other allegations and other crimes in a case is, creates a burden on the defense that it becomes almost impossible to overcome.
Yeah, and let me ask the professor, Kirk. You teach the kids. How do you handle this issue, which can be really kind of rare? California does it. Not everybody does this. How do you deal with this twist to the pattern and signature crime evidence?
Well, it depends what side of the street the students will potentially be working on. So here, if you're the prosecutor, they took advantage. Well, and let me just say that a good attorney should take advantage of the position that they have, the hand that's dealt, or make the best of things. Here, the prosecution took advantage of the hand that they were dealt, and rightly so, right? That's what they were given. So they were able to present the evidence in this combined fashion, and it's very difficult for a jury to find a serial killer, right? Once you throw that word out there and you throw all those victims out there, it's very difficult for a jury to find that person is not guilty. As far as the defense is concerned, I thought they did their best by pointing to a lack of physical evidence, knowing that most lay people are very interested. We all watch CSI and all these different things. And so they want to see physical evidence. So they did a good job. They made the best they could out of the situation.
Jason, the surviving victim, who was the hero of this case, I mean, Michelle Murphy, unbelievable right. What she was able to do the day that this defendant tried to kill her. I mean, you wake up, somebody stabbing you in the chest, and somehow she fought him off. He actually cut himself in the process, and it was that blood and that DNA that nailed them on that case. Didn't help so much directly on the others, but if you're the prosecutor and you have this kind of evidence on one of the victims, you can almost kind of lay down on those, right, and just move forward on the others that you have less evidence on.
Well, you never want to lay down.
Lay down is probably not the right phrase.
But you never want to do that. Certainly, I think that having a live witness obviously is so compelling. Okay, so that takes away any other homicide case. You don't necessarily have a live witness. I do just want to comment on the so-called bootstrapping argument. I'm going to give the prosecution's point of that. It's always a fine line about prior bad acts in general, because of course the prosecution wants to introduce this stuff to get the jury to draw a negative inference in this case. But I don't think you should be able to skate from all of your prior bad acts. And if you have a certain pattern, a certain modus operandi, MO as we call it, why shouldn't it be admissible for these unique circumstances when you have a very unique way of going about committing a crime?
Okay, here's my problem with that. You're asking the jury to say, well, we're not saying he committed this fourth crime out of Illinois, but you kind of have to assume he did to use the facts and pattern in that crime. Because if he's innocent of that, then they're irrelevant for the subject case, right?
That's true.
And that's where I have a problem.
And I totally get that. Okay. I totally get that.
Okay, let's find out how the prosecution used this to their advantage in the closing argument. Here we go. Prosecutor, among other things, is saying, hey, this defendant was so smart, he knew how to clean up the murder scenes of Ashley Ellerin and Maria Bruno. So that's how he tried to explain away they had very little evidence there. Let's take a listen now to some of the defense closing arguments. I think they're unique. Let's listen and we'll chat about it afterwards. Daniel Nardani, the defense attorney, giving this jury his take on, among other things, the use of that Illinois case in the LA case. So here I have with me a law school professor. I have a former prosecutor trial attorney. I have a criminal defense attorney. I got the whole gambit here. I want to talk about, because we did yesterday, Mr. Nardani's performance, his use of what he had to work with. Let me start with you, Matt. How do you think he did?
I love his demeanor. I think that, you know, in a trial like this, you're wondering, is the jury going to like me? Is the jury going to like my client? Well, the jury's not going to like his client. So you've got to put on your best and try to, and I think he's being very effective, kind of being professorial, demonstrating and speaking and articulating compassion. You know, he's trying to really connect with this jury, just between him and the jury, because connecting with his client is out of the question.
Yeah, as with many things in life, in any engagement with people, you know, likability is key. So speaking of professorial, Professor Kirk, what do you think about his demeanor, his style?
I could not agree with Matt more. So I would say that it'd be very difficult for a jury to be sympathetic to his client. So I like the way he walked away from his client, and when he's at the jury, get them to focus on him. His demeanor was very calm. The other thing was the prosecution here, and rightly so, was somewhat aggressive, right? It's certainly in their clothes, they're just very matter of fact. That's a battle he was never going to win. So he can't go toe-to-toe and be as aggressive as them. So I liked his strategy. Once again, it's doing the best you can with what you have. The prosecution was very effective coming back on rebuttal during the close, but I thought that he did a nice job. And this was about reasonable doubt. It wasn't about, hey, look how nice my client is. My client's a great guy. He's being railroaded. He focused on reasonable doubt. And I think that was probably the best that he could hope for.
Now, let me ask you, Jason, this was a different part of the defense closing that had to do with the Michelle Murphy portion of this case. The concept there was the fugue concept, as I'm calling it, that the defense attorney said, hey, you know, Michael Gargiulo didn't really know what the heck he was doing until he was interrupted in the middle of that crime by Michelle Murphy, and at that point he came out of a fugue state. Now, when you come up with a concept like that, what kind of support are you going to need to make the jury buy it? Evidentiary support, expert opinion, what do you need?
All of it was certainly the expert testimony. You know, what I frequently tell, you know, when we go in front of a jury, it doesn't really matter what I say. The lawyer says what I say is not evidence. Certainly we want to put forth our arguments, but for sure you need a rock solid expert to carry that burden. I do want to just comment one thing on the demeanor as well as from the defense attorney's closing argument. He was talking about the Illinois case, and what he was really saying was the prosecution's got nothing here. They're grasping at straws. That's why they're bringing in the Illinois case. Don't buy it.
I thought
he was very effective doing that.
Yeah, that is. And again, it sort of makes my point, but it also does, as best the defense can do, helps take that trump card away from the prosecution. But it is a tough sell. And I will never believe that the jury doesn't weigh that heavily when it comes to their ultimate decision making. So, okay, guys, great case, tremendous analysis. I appreciate that. That is the case of California versus Michael Gargiulo. Done now. Verdict is in next week. They'll get into the sentencing. Again, it is a capital case, and the death penalty is on the table, even in a moratorium state like California. So we'll be with that next Tuesday here at Law&Crime. Okay, coming back in just a couple of seconds here. The latest on R. Kelly. This guy has so many cases, so many jurisdictions. It takes a roadmap to figure it out, and we will do that when we come right back.